providing enough information or information with reasonable certainty, or there were lots of other standards that were thrown out for the court. A petition for writ of mandate can never be used to attack a legislative appropriation directly.
I think I can actually argue that. I've heard him argue that, in fact, the court could make a debt relief determination that, in fact, the legislature's action resulted in violence. So a little bit of a different argument, I think, is what you said.
I heard that the appropriation itself to be held invalid. We would agree that if the underlying program that is authorized by the appropriation was invalid, that is an issue that the court could deal with, but not the appropriation itself. And there's case law to support that. The last thing I'd like to address are these two certifications. And once again, there were more than two certifications that were claims sought for mandate in the Second Amendment complaint. They also alleged that the certification regarding whether an operating subsidy would be required was inadequate in their view. They argued that the certification about whether the municipal segment would be ready for high-speed rail service was also inadequate. They chose to only argue about two of them. One dealt with the environmental clearance, and the second dealt with whether the project could be completed as planned, but that is linked to their argument that the funding plan reporting requirement relating to identification of funding sources was inadequate. We would submit that the language of the reporting requirement is that the authority identify all known and expected, I'm not sure exactly what the word was, sources of federal funding. They did that. They identified funding in place for the ICS, and they identified future possible sources of funding. And that is full and complete satisfaction of the funding plan reporting requirement. Plaintiffs believe that it's inadequate, but that was a decision for the legislature. And that is yet another clue that that the funding plan was mainly for the benefit of the legislature. But if you look at the words of the statutory requirements in the Act, it says include and identify all sources of funds to be invested. And those are included and identified in the funding plan and in the incorporated business plan. Furthermore, all the discussion about the content of these certifications is not supported by review of the Bond Act. There is no requirement of a certification regarding technical feasibility, no requirement of certification regarding financial feasibility. The certifications don't require any content. They require that they be made. Now, I understand, if the authority understands that if they made certifications without any content, then they would be at risk of not getting an appropriation from the legislature, and that's why the funding plan is detailed and it incorporates all of its planning that is set forth in the business plan.
Well, let me follow up on it. Let's assume that happened, that the funding request didn't have sufficient material, and the legislature still appropriated the money. What happens?
The project approved by the appropriation would be constructed. I mean,
even though the funding request was deficient.
If the funding, the requirement.
My premise is this, just for the sake of the example.
Okay.
The funding request is deficient. The legislature receives it, and yet still appropriates the money. What happens?
The legislature assessed that it was deficient. The legislature looked at it and said, we would like more, but this is what we got, and it made its decision. Those are political decisions that I can't comment on, but all that the statute requires, all that the Bond Act requires, is that the sources of all funds to be invested in the corridor be identified. And here it decided that the identification of known and future sources of funding was sufficient for the state to take the risk to invest an initial sum of money in construction of the ICS. All of this assessment of risk is for the legislature. And presumably taking this to the nth degree, the authority could have said, but it didn't, There are no sources of funds to be invested in the corridor, and we're asking you to appropriate funds. It could have done that. I mean, but it's up to the legislature to decide what is sufficient and what is not sufficient, and what risk it's willing to take.
Do you think the O'Farrell line of cases provides any kind of restriction on the legislative action?
In some sense, as I said, the ARPA money is not about a funding plan. It's about the object for which the bond funds were passed, and that is construction of a high-speed train system. And to the extent that the authority is proposing and the legislature is appropriating money to build a high-speed train system that is not consistent with the requirements for use of those funds, then yes, the O'Farrell line of cases is relevant. But once again, that claim is not made in the second amendment complaint. And the funding plan sought an appropriation to build the first part of the iOS South. That is completely consistent with the object of the Bond Act, which was to construct a high-speed rail system. We are now talking about whether there was about funding plan reporting requirements to the legislature. And as I have stated already, those were for the benefit of the legislature, and in any event, we argued in our pleadings, the authority completely complied with those. There is an identification of funding sources. There is no requirement of a certain level of certainty, reasonableness associated with those. There has to be an identification of sources of funding, and they are identified.
Do you think the O'Farrell line of cases, though, at least provides any support for the issue that, in fact, those conditions were something that had to be satisfied?
But who is the judge of satisfaction in this case? It has to be the legislature. It has to be the legislature, because the funding plan is a request to the legislature for money.
But isn't that the role of the courts?
The role of the courts is to determine whether the Bond Act requirements for use of bond proceeds comply with the law. And as I mentioned, there are a laundry list of requirements: design and performance requirements, financial requirements, construction priority requirements. The authority has to build a project that complies with all of those.
But let me ask it this way, and I'll just be very specific. One of the requirements for the funding request was an environmental certification. The environmental certification requirement appears in the past tense. The environmental certification that was provided appears in the future tense. Is that satisfaction?
It was up to. It is satisfaction if you look at the purpose of that. Reporting requirement. And the purpose of that reporting requirement was to ensure that there was no attempt by the authority to circumvent CEQA requirements. And the certification states precisely that before expending any bond money before proceeding to construction, it will have those in place. So if that is the purpose of the certification, then the certification was met. Secondly,
so before you leave that, the language in the statute is past tense. The certification is future tense. So just by its very nature, satisfaction can't have occurred.
There is not a precise match between the certification met and the certification made and the certification requirement. However, there is certainly substantial compliance if you consider the purpose of that certification. And that satisfies the requirement that the certification requirement in and of itself. However, the legislature saw that the certification was a will have certification versus have certification, and it decided to appropriate funds.
But that's why I asked about the O'Farrell line of cases. Does it apply in such a situation?
It does not apply, because the O'Farrell line of cases relates to whether or not there's been substantial compliance with the object of the Bond Act. And the object of the Bond Act is construction of a high-speed train system. The cases, especially the two older cases that the plaintiffs spent a lot of time discussing, deal with Bond Acts that dedicated money to build, in one case, 30 bridges, and in another case, a mile or so of road. And the legislature was proposing appropriations or plans or making decisions that didn't comply with those. In one case, they took money that was dedicated to Bridge A and decided to use it for Bridge D that wasn't among the bridges identified in the bond act. So there was a substantial differentiation between what was proposed and what was authorized. Here, what's authorized, the object, and I think the language of the Constitution and the language of the cases is always asked, what is the object of the bond act? And the object here is the construction of a train system, and the funding plan proposes to construct the first part of that train system. So the O'Farrell cases do not state a basis for finding a constitutional violation in this case.
All right, anything further?
One last point relating to the O'Farrell line of cases. If you look at the O'Farrell line of cases, there is no requirement for 100% precision between the intended uses of bond proceeds and the proposed uses. The language of those cases is about substantial compliance, significant differences. And the facts are always about proposals to use bond proceeds for projects that are not authorized by the bond, by the bond act. In this case, the bond act was not about a funding plan. It was about constructing a high-speed rail system, and therefore the plaintiff's writ should be denied. The funding plan, I made all the identifications and certifications that it was required to do, and the project complies with all the statutory requirements for development of a train system. It meets all of the financial criteria. It meets the construction priority requirements. It meets, to the extent possible, at this very early stage. It was offered with the understanding that it could meet, all design and performance requirements.
Mr. Flashman, any reply you'd like to make?